Simple instruments of transfer. A backward look. Under the early English common law, ownership of real property was transferred by a technique called theft. This involved delivery of possession, which was termed delivery of season. No writing or deed was involved. The transfer was actually effected by a delivery of the land itself, or something symbolical of the land, such as a twig, a stone, or a handful of dirt. Another early method of transfer was by a statement usually made before witnesses in view of the land to the effect that possession was transferred, followed by entry of the new owner. Again, no written instrument was at first required. An interest in land which was not capable of actual possession, termed an incorporeal right, such as an easement, was transferred by a deed called a deed of grant. A conveyance by a release was a deed given to transfer an estate or interest in land. But no livery of season could be given until the new owner took possession, which involved a multiplicity of formalities. A release was also used for the purpose of extinguishing a right in the land and corresponds to its modern descendant, the quitclaim deed. A recording system was unknown to the early common law. Ownership was a matter of common knowledge, and transfer was not often made except by descent from father to son on the father's death. The method of making land transfers in California under Spanish and Mexican rule was somewhat similar to that of the common law. It was early held by the Supreme Court of California that land could not be conveyed under Spanish and Mexican laws without an instrument in writing, unless conveyance of the land was made by an executed contract in which possession was delivered at the time of sale by entry upon the premises and the doing of certain ceremonial acts, which in a sense were like livery of season at common law. The ancient livery of season is symbolized today by the delivery of the deed, not the property, by the grantor to the grantee. The deed is now the symbol of title. The pattern today. Today, Californians most often transfer title to real property by a simple written instrument, the grant deed. The word grant is expressly designated by statute as a word of conveyance. Civil Code Section 1092. A second form of deed is the quitclaim deed. It resembles the common law conveyance by release. Other types of deeds are the warranty deed, the trust deed, the reconveyance deed, the sheriff's deed, and the gift deed. Deeds in general. When properly executed, delivered, and accepted, a deed transfers title to real property from one person, the grantor, to another person, the grantee. Transfer may be voluntary or involuntary by act of law, such as a foreclosure sale. There are several different essentials to a valid deed. 1. It must be in writing. 2. The parties must be properly described. 3. The parties must be competent to convey and capable of receiving the grant of the property. 4. The property conveyed must be described so as to distinguish it from other parcels of real property. 5. There must be a granting clause, operative words of conveyance, e.g. I hereby grant. 6. The deed must be signed by the party or parties making the conveyance or grant. And 7. It must be delivered and accepted. Contrary to the law and established custom in other states, the expression to have and to hold, called the habendum clause of a deed, is not necessary, nor are witnesses or seal required. The deed should be dated, but this too is not necessary to its validity. Any form of written instrument containing the essentials above set out will convey title to land. The typical grant. I, John A. Doe, a single man, grant to Emma B. Rowe, a widow, all that real property situated in Sacramento County, State of California, described as follows. Lot 21, Track 62, recorded at page 91 of Book 7 of Maps of Sacramento County. Filed January 21st, 1965. Witness my hand this 10th day of October, 1983. Signed, John A. Doe. Usually, a deed is executed for consideration, but this is not essential for a valid transfer. Moreover, even when consideration is given for the property, this point need not be mentioned in the deed. However, it should be noted that lack of consideration may affect the rights of the grantee as against the rights of certain third parties, because the recording statutes are intended to protect bona fide purchasers. For example, a transfer made without consideration by a grantor who is or will thereby be rendered insolvent is fraudulent as to grantor's creditors, and those creditors may have the deed set aside in a court action. A deed need not be acknowledged, nor need it be recorded. However, both acknowledgement and recordation are part of the standard operating procedure in real estate transfers for very good reasons. Acknowledgement. An acknowledgement is a formal declaration before a duly authorized officer, such as a notary public, by a person who has executed an instrument that such execution is his or her act and deed. The piece of paper or form executed by the officer before whom the formal declaration was made, for example, the grantor in a grant deed, is a certificate of acknowledgement. This certificate is either printed right on the grant deed itself, or is a separate piece of paper, which is stapled to the grant deed. The acknowledgement of a writing is a way of proving that the writing was in fact signed, or executed by the person who purported to sign, or execute, the writing. Moreover, an acknowledgement is a safeguard against forgery and false impersonation. Duly acknowledged writings are entitled to be introduced into evidence in litigation without further proof of execution. Many instruments are not entitled to be recorded unless acknowledged. Unless by statute an acknowledgement is made essential to the validity of an instrument, the instrument itself is valid between the parties and persons having actual notice of it, though not acknowledged. The time of acknowledgement is almost invariably immaterial if the rights of innocent third parties do not intervene. Where acknowledgments may be taken, and by whom, anywhere within the state, proof or acknowledgement of an instrument may be made before a justice, retired justice, or clerk of the Supreme Court, or District Court of Appeal, or the judge or retired judge of a superior court, or, after September 17, 1959, a notary public. Before that date, a notary could not act outside the notary's own county. In this state and within the city, county, and county, or district for which the officer was selected or appointed, acknowledgement of an instrument may be made before either a clerk of a municipal or justice court, a county clerk, a court commissioner, a judge or retired judge of a superior, municipal, or justice court, or certain other local officials. Civil Code Section 1181. Acknowledgments may be made and taken by any deputy of the foregoing, duly authorized by law. Also, certain military officers are authorized to take acknowledgments of persons serving in the armed forces. Civil Code Section 1183.5. The principal form of acknowledgment authorized by California law is provided for in Civil Code Section 1183.5. An acknowledgment taken outside this state must be in accordance with the forms, provisions, and laws of this state. If not, it should have attached thereto a certificate of a clerk of the court of record of the county or district where the same was taken, or of a consul or consular agent of the U.S. or judge in a foreign country. The certificate of acknowledgement must state that it is in accordance with the laws of the state, the United States, or the foreign country in which it was taken, and that the officer taking the same was authorized by them to do so, and that the signature is true and genuine. A form of acknowledgement called an apostille may be used in California to authenticate a certificate of acknowledgement drafted in a foreign country. If the certificate of acknowledgement is sufficient in other respects, it will not be invalidated by a mistaken. Where the date of the deed is subsequent to that of the acknowledgement, the later date may be taken as the true date of the deed. Date, or even by the absence of a date, it is sufficient that such date appears by evidence within the instrument itself, and in the absence of proof to the contrary, it may be presumed that the acknowledgement was taken on the date of the execution of the instrument, or at least before the recordation thereof. Where the date of the deed is subsequent to that of the acknowledgement, the later date may be taken as the true date. The deed, the certificate, must be authenticated by the signature of the officer followed by the name of his or her office. An official seal must be affixed. The officer is by law required to have a seal. California, a notary public must provide and keep an official seal, which must clearly show when embossed, stamped, impressed, or affixed to a document, the name of the notary, the state seal, the words notary public, the name of the count, wherein the bond and oath of office are filed, and the date the notary public's commission expires. In addition, the notary stamp contains the sequential identification number, commission number, assigned to the notary public, as well as the identification number assigned to the seal, manufacturer, or vendor, because the legal requirement that the seal be photographically reproducible. The rubber stamp seal is almost universal. However, notaries public may use an embosser seal in addition to the rubber stamp. A notary public is required to keep one active sequential journal at a time of all acts performed as a notary public. The journal must be kept in a locked and secured area under the direct and exclusive control of the notary public. The journal must include the items shown below. Government Code Section 8206, date, time, and type of each official act, e.g. acknowledgement, jurat, character of every instrument sworn to, affirmed, acknowledged, or approved before the notary public, e.g. deed of trust, the signature of each person whose signature is being notarized, a statement that the identity of a person making an acknowledgement or taking an oath or affirmation was based on satisfactory evidence pursuant to Civil Code Section 1185, the fee charged for the notarial service. If the document to be notarized is a deed, quitclaim deed, or deed of trust affecting real property, or power of attorney document, the notary public must require the party signing the document to place his or her right thumbprint in the journal. Government Code Section 8206 specifies alternatives if right thumbprint is not possible. Acknowledgments taken by officers having an interest in the transaction. In general, case law has consistently provided that officers who take an acknowledgement of a writing should not have a direct financial interest in the transaction. The purpose of the prohibition is to discourage fraud, and if an acknowledged instrument discloses on its face that such conflict of interest exists, it has been held the recorded instrument does not impart constructive notice of its contents. No reliance should be placed on instruments acknowledged before an officer who is known to have, or who may reasonably be expected to have, a direct financial or beneficial interest in the transaction. For example, an officer acknowledging his own signing of a document or instrument, an officer acknowledging a mortgager's execution of a mortgage naming the officer as mortgagee, and an officer acknowledging a deed in which he or she is named as grantee. An acknowledging officer who is one of several grantors or mortgagers may properly acknowledge signing of the instrument by the other grantors or mortgagers, but his or her own signing must be acknowledged by a different officer. Effective January 1, 1978, the following statutes became effective with respect to the acknowledgments taken by notaries public. Government Code Section 822. A notary public who has a direct financial interest in a transaction cannot perform any notarial act in connection therewith. Transactions covered include the following. 1. Financial transactions in which the notary public is named individually as a principal. 2. Real property transactions in which the notary public is named individually as grantor, grantee. Government Code Section 8224.1. A notary public cannot take the acknowledgement or proof of instruments in writing executed by him or by her. Certain instruments must be acknowledged by affected party. California law protects property owners from unwarranted or unauthorized encumbrance of their property on the official records. Most instruments affecting real property must be executed and acknowledged or proved by the owner of the property before the instrument is eligible for recordation. Among such instruments, besides conveyances, mortgages, and trust deeds, are agreements for sale, option agreements, deposit receipts, commission receipts, or any affidavit which quotes or refers to these instruments. Any instrument transferring or encumbering community property must be executed by both the husband and the wife. Recordation. While recording a deed does not affect its validity, it is extremely important to record since recordation protects the grantee. If a grantee fails to record, and another deed or any other document encumbering or affecting the title is recorded, the first grantee is in jeopardy. The recording system is established to show the sequence of transfers or other actions affecting property, and it is foolish to fail to avail oneself of the privilege of recording. Possession of property also gives notice of the rights of persons in possession. A person buying real property should not rely entirely on a title policy, but should investigate to see if somebody is in possession and find out what their rights are. The occupants might be in possession under a partly paid contract to purchase and sale, or they could be in possession under a lease that gave them an option to buy. Consistency of names and title instruments. Complete record title to land cannot be established unless the various instruments in a chain of title in the recorder's office show direct connection.